All right, welcome everyone to the Freedman Institute's panel presentation on Kurtzrock, a new era in prosecutorial accountability. I'm Teo Liebman, and I'm going to be the moderator of this panel. I'm really happy to welcome all of you. We've got a lot of people here who are ready to listen to and also participate in by asking questions to this panel. I'm going to just take a minute now to introduce our panelists, let you know who's here. And then I'll talk a little bit just about the format, how the panel's going to run, and introduce the case we'll be talking about. And then I'm going to let the panelists do their thing. So our panelists today, we have Brendan Ahern, who is a prosecutor at the Suffolk County District Attorney's Office. He is the acting Deputy Division Chief of the Trial Division. And he was the defense lawyer on the underlying criminal case where the violations occurred in this disciplinary matter. He is also a Hofstra Law School grad from 2007. So we're very proud to welcome him home. And thank you so much, Brendan, for accepting our invitation to talk today. We really appreciate it. We also have on our panel Fred Klein, who is a professor here at Hofstra, where he teaches multiple criminal law related classes and externship programs. Fred has worked as a prosecutor for most of his 39 plus years in practice, including serving as the chief of the Major Offense Bureau in Nassau County District Attorney's Office, where he personally tried more than 100 felony cases. Thank you, Fred, for joining us. And then we have Ellen Yaroshefsky, who is the executive director of the Freedman Institute and the Howard Lichtenstein Distinguished Professor of Legal Ethics here at Hofstra. Among her many accomplishments, some of the ones that are relevant to today are she has received the New York State Bar Association Award for Outstanding Contribution in the field of criminal law education, and she currently co-chairs the Ethics Committee of the National Association of Criminal Defense Lawyers. All three of those folks have many other accomplishments, and you can click through to see them, but I figure you would rather listen to them than hear about their accomplishments. So for the format today, I will be moderating the panel, and I obviously have some questions for them, but I also will be asking questions that you all can submit in the chat, and I will get to as many of those questions as I can. Please do keep in mind that almost all of the panelists, I think all of these panelists, are involved in active cases or legal matters related to issues of Brady and ethical responsibilities to disclose information to the defense, and so they will not be answering questions about those specific cases that they're involved in. Instead, the focus is really going to be on some of the background to the Second Department's December 2020, so just a couple of months ago, decision in the matter of Kurtzrock, and figuring out what it might mean for the future of prosecutorial accountability. I should mention that we were supposed to also have Fred Brewington here as a panelist. He is busy because he is testifying before the Nassau County Legislature on police reform. He sends his regrets that he couldn't make it. Okay, I'm going to take a couple of minutes, give the background of the Kurtzrock decision. My guess is that many of the people who are here to listen to this panel present have read the decision, but I do want to make sure that everyone has some understanding of the background. So I'm going to provide a little of that before we get to the panelists. So Glenn Kurtzrock was a district attorney at the Suffolk County District Attorney's Office and a longtime prosecutor there. And a disciplinary proceeding was instituted against him in 2019 for professional misconduct. In the process of prosecuting a home invasion, burglary, and murder case that he prosecuted in 2015 and 2016. And in that disciplinary proceeding, before a referee, key factual findings that were made against him were that he had knowledge of, but failed to turn over information about another suspect that the police had looked into, information that undermined the credibility of the main prosecution witness, and also information that undermined the credibility of an alleged accomplice who was cooperating with the government. And so the referee found that Mr. Kurtzrock had failed to turn over that information. And it found that those actions constituted violations of a couple of different ethical provisions. First, it found that the referee found that it was a violation of the prosecutorial responsibility under the ethics rules to timely disclose the existence of evidence that tends to negate the guilt of the accused or mitigate the degree of the offense. It also found that it constituted a Brady violation to turn over exculpatory or impeachment evidence. The referee found that it was conduct prejudicial to the administration of justice, violated that rule, and that it was conduct that adversely reflected on Mr. Kurtzrock's fitness as a lawyer. So it found those violations. Now, Mr. Kurtzrock admitted at the grievance hearing before the referee that he should have turned the information over, did not contest that was an error on his part. But he did provide mitigating evidence regarding what the appropriate sanction should be, and including that there was no intentionally malicious conduct, that there was no showing of similar conduct in other cases, that he was remorseful, that he didn't have a prior disciplinary record, that he had engaged in community service, and that during the time of the criminal case, a member of his family had a medical issue, which had created an additional burden for him. And so his lawyers were asking for a sanction of public censure. And so the Second Department, in determining the sanction, agreed that those were mitigating factors, but also found aggravating factors, including that he had violated, or the violation had been committed in his capacity as a public officer who was charged with seeing justice was done, that he was a seasoned prosecutor and really should have known better, that his actions deprived both the defendant of a fair trial, but also the victim's family of a determination of the defendant's guilt. And then imposed a sanction of a 2-year suspension from the practice of law. So Mr. Kurtzrock's lawyers had asked for public censure, and the Second Department sanctioned him with a 2-year suspension from practice of law. And so that's what the background is in terms of the disciplinary proceeding. I want to turn this over now first to Brendan, because Brendan was the defense attorney in the case. Before he was a defense attorney, he was a prosecutor, and after he was a defense attorney, he's been a prosecutor. But at that point, he was a defense attorney. Brendan, I'm hoping that you can give us some understanding of sort of the underlying criminal case where the violation occurred and the significance of the material that was not initially disclosed.
Sure. Thank you, and good evening. Thank you for that introduction. And initially, I just want to thank Hofstra Law School for hosting this important discussion tonight and for inviting me to participate along such important voices in our legal community. And certainly we regret to not also appear alongside Mr. Brewington. And I'm aware that there's some students in the audience today, and to my former professors and the greater Hofstra Law community, I just want to say it's great to be back, albeit virtually, here at Hofstra Law School, because I do remain so incredibly grateful to this institution, particularly the clinical and trial advocacy programs, which gave me the tools, skills, and confidence necessary to succeed as an attorney. I've remained engaged with Hofstra since I left. The trial ad programs, Professor Krieger's evidence classes, alumni committee engagements with law students, OCI with Hofstra's very talented law students, and tonight to come back here to join this esteemed panel to discuss this important and perhaps seminal case in the criminal justice system. As it relates to the Booker case, turning the page to the Booker case, which gave rise to the matter of Kurtzrock. I'll first set the stage of background. In 2015, I was working, as you mentioned, as a criminal defense attorney for a prominent law firm here in Suffolk County, focused primarily in criminal defense. And I had a background, as you mentioned, of being in the Nassau County District Attorney's Office, coming up from intern to DA, to a homicide prosecutor, trial supervisor, and ultimately a deputy chief. Now, as I was out into private practice in 2015, I'd been screened by a committee and found qualified by the Suffolk County Assigned Defenders Association to serve on both the felony and homicide panels, representing indigent individuals, indigent legal services. And I was found qualified to to represent on the most serious of cases, on murder cases. In November 2015, I was assigned my first homicide panel case, when I was assigned the case of People versus Messiah Booker. And as you mentioned, Mr. Kurtzrock was the assigned prosecutor on the case. The allegations were that Mr. Booker, he was indicted along with 3 other co-defendants with the offense of felony murder and burglary. It was alleged that Mr. Booker, his brother, his sister, and another committed an armed home invasion at a small home in Flanders on January 27th, 2013, and that during the burglary, a physical altercation had broken out, and it was alleged that Mr. Booker was involved in that altercation and ultimately shot and killed a young man named Dimitri Hampton, who was inside the home. And I know we have many attorneys on here tonight, but for the students, felony murder, the basic premise is that 4 individuals were alleged to have shared the same purpose in committing an armed burglary, and one of the participants was alleged to have caused the death of another, and that resulted in all 4 of those participants being charged with the offense of murder. In terms of evidence, there was no physical evidence or forensic evidence such as fingerprints or DNA that tied Mr. Booker or the co-defendants to the offense. However, there was cell phone tower data indicating that the alleged participants were in the vicinity of the incident on the date and time of the offense. And additionally, there was alleged to be an individual in the home who recognized a voice from one of the intruders to be that of Mr. Booker. That was because following the shooting of Mr. Hampton, a person was alleged to have heard someone say, "Jay Sean, WTF, that wasn't part of the plan." Now, there were early practical challenges in the defense. I was assigned to represent Mr. Booker, meaning that the defendant did not select me as his attorney. I was court appointed. And for any of our colleagues that have worked in Legal Aid Society or other indigent legal services, like my father and my father and my wife have, in some instances, that can present a unique challenge to gaining trust between the client and the attorney. And I think that that would be a fair description of these circumstances. Additionally, the defendant at the time of the assignment and throughout the pendency of the case was a sentenced prisoner for a separate weapons charge. And that meant that initially he wasn't local all the time and accessible to discuss the case and prepare his defense. And lastly, Mr. Booker was a self-proclaimed sovereign citizen, which is a complex belief system that effectively holds that he did not believe that the courts or the US government had lawful authority or jurisdiction over him. Now, at the time that this case commenced in 2015, New York State was still operating under the former discovery statute, Article 240 of the Criminal Procedure Law, which, so in accord with that, I filed about 1 month after the arraignment, a discovery demand and a request for a bill of particulars. And included within that demand were both general and specific Brady demands. Later on, in February 2017, we were on to the trial track of the case, and I filed another motion. I filed a severance motion and a motion for an order to compel Brady and Giglio materials. And in reference to the severance, which is relevant to our discussion, I believe, tonight, I was seeking to have Mr. Booker tried separately from the other co-defendants, but in particular, his brother, Mr. Wallace. And that was because I had raised to the court's attention that the fact finder was going to have to make a reliability and accuracy determination about this so-called ear witness. We have eyewitnesses. I would describe this as an ear witness, someone who heard the identity of the individual. And I brought to the court's attention in my motion that the true identity of the individual or individuals that were present inside the home would cause, if Mr. Wallace and Mr. Booker were tried together, antagonistic defenses. And so I raised to the court's attention in my motion that this ear witness was something that I intended to challenge significantly. Parenthetically, I would mention that I was preparing an expert witness who had done a voice comparison of Mr. Booker and Mr. Wallace and had prepared what they call time-varying acoustic spectrograms or voice prints to challenge whose voice it was that said, Jay Sean, WTF, that wasn't part of the plan. But the other part of the motion, as I said, was a motion to compel discovery, Brady, and Giglio material. And as relevant to our discussion tonight, I specifically requested any information about any alternative suspect. I asked for any information regarding any investigation into a different suspect or an individual alleged to have committed the offenses for which Mr. Booker was charged. And then I went through in detail and I asked for Crime Stopper tips, which are basically leads. I asked for any lead regarding any other defendant. Specifically, I asked for leads regarding any blood gang members that were alleged to be involved. And I specifically named one particular alleged gang member who I asked if there was any information about his potential involvement. I also asked for any information that any of his associates may have been involved. And lastly, specifically, I asked any information suggesting that any witness against the defendant had recanted or vacillated in his or her statement to law enforcement about the identity of the defendant. In late March of 2017, Mr. Kurtzrock made a Molyneux application to introduce what they call prior bad acts at the trial. And relevant to this discussion, he wished to introduce evidence that another person had possessed the murder weapon a couple weeks before the trial, and a belief that they were involved in a shooting at a club, and a belief that Mr. Booker was at that club. And I opposed this Molyneux application and it was denied. But I brought to the court's attention that a new Brady request, because I raised that any evidence that any individual possessed the murder weapon or was involved in this offense should have been provided over earlier. And I was asking for any other information that would lead to a different person being alleged to be a suspect of this offense. Additionally, within the Molyneux application, I was provided a license that was found at the scene of that shooting. And the name on the license was Jason. I investigated that individual and learned that Jason had an extensive criminal history, including prior violent acts. And I was concerned that Jason may in fact be Jay Sean that was heard by the witness inside the house. In response to that demand, I received a detailed analysis from Mr. Kurtzrock about Brady, laying out the legal standards for Brady analysis and the timing requirements for Brady disclosures. Now, moving closer to trial. On April 11, 2017, a few days before trial, I requested the Rosario material, the written or recorded statements of any of the witnesses intended to be called at trial. And I indicated I wanted them about 1 week before jury selection because I wanted to be able to go through these materials methodically, like I had gone through all the other discovery that had been provided to date. A few days later, on April 14th, I received the Rosario materials. And I think relevant to tonight's discussion, there was a cover sheet detailing what was enclosed. And notably, the cover sheet did not indicate that any material was missing or that there had been any type of legal analysis done to determine that I was not entitled to materials that had been withheld. And that, I believe, is particularly important because I believe that if I was given notice at that moment that there was material that was withheld, I could have made an application to the court before jury selection and the trial began. But I didn't have that opportunity because I wasn't made aware. And that would later become relevant because, for instance, the lead detective's notebook was noted as 40 pages on that cover sheet, and it appeared to be a single memo book. But in actuality, I later discovered that the memo book was nearly 120 pages and spread out across 4 separate memo books. On April 2017, we commenced jury selection. A little-known part of the case is that prior to jury selection, Mr. Booker attempted to fire or discharge me as his attorney and sought to represent himself pro se. That caused the trial judge, Justice Collins, to do a comprehensive inquiry of Mr. Booker regarding his ability to represent himself. And I will always recall arriving near the end of that exhaustive inquiry and Justice Collins asking Mr. Booker, and forgive me for paraphrasing, don't you think it would be a good idea to let Mr. Ahern represent you? And I guess you could call that a pivotal moment, because he agreed to allow me to represent him going forward, but also elected to exercise his right to not be present in the courtroom for jury selection. And so I began that day my very first jury trial as a defense attorney by picking a jury and giving my best explanation to a jury of why I was representing an empty chair. And notably, Mr. Booker did return to trial on day 2. There was the same panel of potential jurors. And so I was able to now explain to them how wonderful our criminal justice system is, that you can elect to attend one day and not attend another. Now, noteworthy as we began the trial, Mr. Wallace, Mr. Booker's brother, had pled guilty to murder, and he agreed to testify against Mr. Booker. When I received the Rosario materials, I learned that Mr. Booker's former girlfriend, who was alleged to have driven one of the cars to the home on the night of the home invasion, agreed to also testify against Mr. Booker in a cooperation agreement. I also learned for the first time that the occupants of the home where the incident had occurred only saw 2 armed intruders, even though the theory of the case was that 3 defendants had entered the home. But the witnesses saw 2 people come in and 2 people come out, and that's all the information that they reported to the police about what they had observed. And so my opening, therefore, was focused on this issue, that Mr. Kurtzrock was going to seek to convince them that 1 + 1 = 3. And in light of Mr. Wallace's plea of guilty, there was only one more individual who would be identified as being involved and inside the home. And my theory was that my client did not enter that home and did not share the criminal intent of Mr. Wallace. And ultimately, the argument would have been that Mr. Wallace went into that home to score drugs at that residence, and that the single other person who went in with him was not my client. Now, fast forward. The trial commenced and moved along, and Mr. Kurtzrock was set to call his final witness, a lead detective. Prior to his testimony, as I was going through the materials, literally moments before, in that last-minute prep before the witness took the stand, I noticed a gap in dates in the detective's 40 pages of memo book entries. There was a 2-year jump. And when I inquired of Mr. Kurtzrock why that was, the misconduct that had occurred was quickly realized. It was explained to me that those notes were not provided because there was no intention to have testimony about those 2 years. So it didn't constitute Rosario. Mr. Kurtzrock also told the judge and I that he had performed a careful review of the materials and it contained no Brady. In fact, when the rest of the memo book was turned over, it wasn't just those 2 years. It was actually, as I described, a surgical extraction of exculpatory evidence. There was pages all throughout the investigation that had been removed and secreted. The notes revealed that multiple other people had been identified as being involved and being the shooter. That specific gang member that I was inquiring about was spoken to days into this investigation, and others were also looked at as targets and individuals involved in violent street gangs. And included in that was a man named Jay Sean, who was identified with his full name and an address, and was identified as being involved by family members. The trial was put on pause upon this realization, and it would never resume. Over the next several days, I demanded and received more withheld material. Eventually, I asked for everything under the sun, the broadest scope demand that I could ask for, and I was provided what I believe to be the entirety of the file under a sealing order. And when I went through this, the material was several phone books stacked high. It was voluminous, and it was filled with what I quickly identified, particularly as my experience as a former prosecutor, was clearly Rosario material related to witnesses who had already testified, in particular that ear witness, and a whole host of Brady material, the most noteworthy of being the identity of other suspects, other shooters. But it also included derogatory information or giglio material of witnesses who had already testified. So the steps that I took. For days and nights, I didn't sleep. I sat at my dining room table, drinking espresso, and did a slow, methodical review of every single document. I conducted a detailed comparison of the materials that I'd received, and I prepared a presentation to make in court. I also sought counsel with other bright legal minds and experienced litigators, including my law partner at the time. And they all gave me incredibly sage advice. And for those who know who they are, I'm incredibly grateful for that advice because it helped me guide through a very complex process that was fast moving. They advised that I prepare myself diligently and prepare a clinical approach to the presentation, to let the power of the material, the factual findings, speak loudly. Do not make the mistake of some attorneys to make wild accusations without backing it up with facts. So on May 9th, 2017, after plea discussions had broken down, I attempted to make a clinical factual presentation of facts. Piece by piece, I went through every piece of Rosario and compared it to what I had received and what was withheld, going through the notebooks of the lead detective, an assisting detective, and other long form notes that I had received. Over the course of the morning, I presented a couple of hours worth of material that had been not provided. And I was about 1/3 done when we broke for lunch that morning. While at lunch, I was sitting down in the office of the Suffolk County Legal Aid Society, continuing to prepare my proposed remedies when we would get to the close of this hearing. And during that lunch, I was contacted by a high-ranking executive from the former administration who offered me a plea disposition. And so I took that offer to my client. After discussing it, my client elected that he wanted to take advantage of that plea disposition. And so we walked into court, and at that time, Mr. Kurtzrock had been replaced by his chief, and another attorney stood in his stead, and they dismissed the murder charge, and they reduced the burglary charge to an attempted burglary in the second degree with a minimum legal sentence that was allowable by law. And subsequently, in the coming months after this, they would be required really to dismiss the murder charges against all of the co-defendants, including Mr. Wallace, who had pled guilty to murder, because similarly, the attorneys for those individuals had not been provided these critical information. And so lastly, on the date of sentencing, I would note that the decedent's family was incredibly gracious to me. Prior to the trial, I had approached the family of the deceased, and I expressed my condolences to them for their loss. And I explained to them that I would say a prayer for them. And I said, please understand that I will have a job to do representing my client in this case. And I thought that that was the decent thing to do. Because I knew that you can be a zealous advocate for your client, but still be decent, still be courteous and respectful of a victim's family. And in the end of those sentencing proceeding, the mother of the decedent gave me a hug, believe it or not, in the courtroom on the date of sentencing, and told me I did my job, but that Mr. Kurtzrock had not done his. Afterwards, I spoke publicly for the first time about these circumstances, and I went back to read that quote recently, and I'll read it to you now as I finish my remarks at this time. I said, it's my solemn belief that this case can still stand for something good and something just if it stands for fundamental change, to allow the accused full access to all the evidence, both for and against them. And I guess I would leave it there because perhaps that was in part a prelude to some changes that then would later occur in the law.
Thanks so much, Brendan. It's so valuable to hear, not just your perspective as the person who was so intimately involved with that case, but also some of the pieces of what happened that don't make it into any of the decisions, that don't make it into any of the reported pieces of it. So I really appreciate you sharing that stuff. A reminder, we will take questions that are in the chat once everyone's had a chance to speak. If you want to put questions in there, you can, but as I said before, we are not going to be asking questions about people's individual matters. All three of the panelists here have cases going on that where there are, of course, or have had cases that involve Brady issues, so we are not going to be discussing those. So those questions won't be asked in this panel. Ellen, let's zoom out just a little bit. We've now heard a little bit about the specific case. Give us a little bit of the historical perspective of disclosure issues with prosecutors.
Thank you, Taya. When you said zoom out, I thought you wanted me to move back.
No, stay on the Zoom, but okay. Zoom out perspective-wise.
I'm going to step back and provide somewhat of a historical perspective on Brady violations and lack of disciplinary consequences, because these are very long-standing issues. Brendan, I really appreciate what you had to say, and I wish I could say that Booker was a unique case. It is not. I wish I could say that I thought it would lead to fundamental change. All I can say is I'm hopeful that it will lead to some change, but we have yet to see that. So let me start here. In the last 10 years or so, there's been significant and increasing attention to prosecutorial accountability for misconduct by courts and by some disciplinary authorities in some prosecutors' offices and by defense organizations. Much of it is the result of recent attention and increased attention in the last 20-something years to wrongful conviction cases. One of the 5 causes of wrongful convictions is government misconduct, and Brady and Giglio violations are the #1 reason for wrongful convictions due to prosecutorial misconduct. There's something called the National Registry of Exonerations, and they issued a report in 2020, which noted that of the 2,400 exonerations around the country, 30% were because of prosecutorial misconduct, 35% involved police misconduct, and overall, what they call government misconduct existed in 54% of cases. With respect to prosecutors, most often these wrongful convictions based upon prosecutorial misconduct were for suppression of evidence. I will put in the chat the report for people who are interested in following that. It's an excellent report. There's been long-standing disagreement as to how prevalent these Brady violations are. Judge Kaczynski of California, formerly of the Ninth Circuit, famously claimed that there's an epidemic of Brady violations. And prosecutors, particularly in prosecutorial organizations, have long said, that's not true, they're episodic, right? And we're never going to have an agreement as to the extent to which there are Brady violations, because we won't know. Brady violations are a hidden problem. 95% of our cases or more result in guilty pleas, and much of the information isn't turned over, or if it is, and we'll never ever know that, leaving us with few accountability mechanisms to determine whether evidence was ever disclosed. So there's never going to be an analysis of how significant the problem is, all right? Let me just step back for a second and talk about what do we mean by misconduct? For disciplinary purposes, when we're talking about misconduct, we're talking about knowing or intentional conduct. When we talk about prosecutorial misconduct in the law, which is to say, what gives rise to a reversal of a conviction, it includes both the prosecutor and the police. So what that means is prosecutors are sometimes blamed for conduct when they're not blameworthy. They may have done a diligent effort of trying to get information from the police, but the agency doesn't turn it over. And if in fact the court finds that it would have resulted in a different verdict and they result, and they may reverse, they will call it prosecutorial misconduct. And I think prosecutors rightly bristle at that because it may not be their individual fault. I've long said we should use the term government misconduct in appellate cases rather than prosecutorial misconduct. But I just provide that for you for this discussion so that we know what it is we're talking about. When we talk about disciplinary consequences, we're talking about actual knowing or intentional misconduct by an individual prosecutor, not by prosecutors supervising the police. So for those cases, and those are the cases that are talked about in the National Registry, there are many studies over the years. I actually wrote about this some 20 years ago that demonstrate nationally there has been very little, if any, discipline of prosecutors who have engaged in this kind of conduct. There are very few cases where courts have held hearings, although they're starting to do that more frequently now, or where courts will impose sanctions or even refer lawyers to a disciplinary committee, which a judge, frankly, should do if before then they have a case where they know that a prosecutor or they found that a prosecutor has engaged in intentional misconduct. We talk across our democratic institutions about the need for transparency and the need for accountability. And there's certainly a need to do so within our criminal justice system, but the reports that have been issued over the years, the studies that have been done show that there's very little of it. And in a minute, I'm going to talk about what happened in the Kurtzrock case and the disciplinary matter itself, because there was very little transparency in that as well. There are a number of notorious cases, and probably most of you know about those, where prosecutors were disciplined. They're few and far between. So in the Duke Lacrosse case in 2007, Michael Nifon was a prosecutor who was disbarred among the reasons for failing to disclose exculpatory evidence, DNA exculpatory evidence. In the famous Texas Michael Morton case, Michael Morton served 25 years for the murder of his wife and his child, who he stumbled upon when he came home. Ken Anderson, the prosecutor, hid a significant amount of evidence of the real perpetrator. That prosecutor became a judge, and in a unique procedure in Texas some years ago, it's called the Court of Criminal Inquiry, they put Ken Anderson on trial. He was a judge, but he was the only prosecutor in the country who went to jail. He was sentenced to jail for 10 days for his conduct. That led to changes in the discovery laws, with Texas leading the country with the best discovery laws. That was a year before the discovery laws were changed in New York. Orange County, California, the entire prosecutor's office was disqualified in a 2017 case because there was a scandal that the prosecutors over time had hidden evidence and colluded with jailhouse informants for false testimony, and they had been using a secret database for decades. There was no discipline of any prosecutor in that office. It did, though, lead to California passing a law that makes it a felony to intentionally hide evidence. Charles Sebastian, he might not be as well known, but he's another Texas lawyer who was disbarred for withholding exculpatory evidence of a man named Charles Grave, who was on death row for 14 years, ultimately exonerated. In a famous case that went to the Supreme Court, John Thompson was on Louisiana death row. He had 5 separate death sentences. And a month before his execution, an intrepid investigator for the defense located the fact that there had been a blood sample that no one had ever seen. And it turned out that the prosecutor in the homicide case against Thompson had taken the blood evidence home. He kept it in his garage for years. He had revealed the existence of it to another DA who ultimately came forward after Deegan, the prosecutor, died of cancer. Ultimately, Thompson was exonerated. He went on a national tour with the Innocence Project to discuss prosecutorial misconduct. I was with him at times, and he would say, the prosecutor tried to kill me. Why wasn't he indicted for homicide? It's a chilling question that he would ask of every audience. And frankly, explain to him that that's not the definition of homicide wasn't exactly fulfilling. In federal court, the most famous case, Senator Ted Stevens, he was found, the government just ultimately threw out his conviction, with Judge Emmett Sullivan in the DC court stating, and this was the quote from the newspaper, in a slow and deliberate manner that failed to conceal his anger, In my 25 years on the bench, I've never seen mishandling and misconduct like what I've seen by the Justice Department prosecutors who tried the Stevens case. More recently, Judge Ali Nathan in the Southern District, in a case called Ali Najad, she was so bothered by the conduct of the Southern District prosecutors in withholding evidence that she held a hearing. She ordered every prosecutor in that office to read her opinion. She required an affidavit from the head of the office in order to ensure that everyone had read that. So these are cases that have been in the news. They're few and far between. Many people will argue these are just the tip of the iceberg, but maybe they're indicating some move forward. Here's what happened in the Kurtzrock Disciplinary Committee hearing. You may not know this, but disciplinary committee hearings in New York are all in secret. There's no transparency. Unlike other jurisdictions like Massachusetts or Pennsylvania, where hearings are open after a finding that there's probable cause to go forward, where there is a robust attempt to take discipline seriously, in New York, there is no transparency. Here, it took 3.5 years after Kurtzrock was fired. He was fired by the Suffolk County District Attorney's Office. That takes a lot. Newsday had reported that there were 5 homicide cases by Kurtzrock that had been reversed, all right? In that 3.5 years, Kurtzrock became a defense lawyer. He touted himself as a, quote, former homicide prosecutor. In those 3.5 years, ultimately, the Innocence Project and 6 news organizations filed a motion to open the proceedings. There's a good cause provision in the law saying for good cause, we can open the proceedings, but the disciplinary authority said no. And so they held it in secret. The Innocence Project, the news organizations had said, what could be better cause than a public official who was charged with engaging in misconduct? Why wouldn't we open it here? Okay. As Teo pointed out in the beginning, he was given a 2-year suspended sentence. Many people would say, wow, that's a lot. That's not happened to a prosecutor before. But the problem here is that there was no transparency, and the disciplinary authorities claimed that there was mitigation, claiming that this was the first instance they knew of him engaging in this kind of conduct. That was not true. Newsday had reported numbers of previous cases, including a famous one called Sean Lawrence that Kurtzrock was involved in. The Innocence Project had submitted pleadings. They tried to submit pleadings to the disciplinary authorities indicating Kurtzrock is a repeat offender. As I've said, Newsday kept reporting about this. After the 2-year ruling was handed down by the disciplinary authorities, the Innocence Project, once again, with a lawyer named Paul Sheckman, well-known former U.S. attorney, head of a bureau in the U.S. Attorney's Office in the Southern District, wrote a letter to the disciplinary authorities, once again saying, we think that you should reconsider. Here's the other information about Kurtzrock. Here's the other information about the Lawrence case. Here's the other information as to why he is a serial offender. And the disciplinary committee wouldn't even file the letter because they said the Innocence Project and Sheckman aren't parties. So they ended up sending the letter to the grievance committee to file. And to this day, they got acknowledgement that they received it, but it's not even clear that it was filed. So there's serious questions, certainly about the extent to which these violations exist in New York. It's clear that very little has been done in the past. There's a commission in New York that's been set up, the Prosecutorial Judicial Complaint Center, that has filed against other lawyers who have engaged in serious Brady errors and misconduct, and nothing, or very little, if anything, has gotten done. So there's questions, I think, Teo, one of the questions you want to raise is whether this is a new era in terms of discipline in New York. My fear is it's a new era of not doing what should be done. It is my firm belief that if Kurtzrock is not going to be disbarred, I don't know whoever would be in the future. And maybe what we are doing is only setting a standard, and a very low standard in terms of disciplinary consequences. And the final thing I'll just talk about before we move on is many of you know that there was a bill for a commission on prosecutorial misconduct. There was a law that was passed. A part of it was declared unconstitutional by the court. The bill is once again before the legislature. I believe a constitutional version of it will be passed, but we can talk about whether that commission is really going to cure the problem. I don't think it will. It may be a step forward, but we're still left with a lack of transparency and with a lack of actual accountability. So
Thanks,
thank you.
Helen. Yeah, no, thanks. I'm going to definitely come back to some of those questions you raised. I want to give Fred first a chance to give us some of the perspective of someone who's been prosecuting cases for a long time, and maybe can give us some insights into some of what a prosecutor is thinking or has to deal with when confronted with a decision about turning material over.
Well, first of all, I really want to thank Professor Liebman and Professor Yaroshefsky for giving me the opportunity to participate in this panel. These are two nationally recognized experts on legal ethics, and for me to be able to be on the same computer monitor with them is an honor that I never thought I would have. I also want to thank a professor here at Hofstra named Roy Simon, who 12 years ago, when I started as a professor and not really knowing what I was doing, he kind of recruited me to take up research and writing on Brady as a prosecutor. I wrote a law review article several years ago, I think it was about 11 years ago, which some DA's offices actually use for training right now. And I owe that to Professor Simon because he had asked me to do that. And finally, I want to thank Brendan Ahern for participating in this program. You know, I've been a prosecutor for 30 years and I've been a professor now for 12 years and I've been involved in Brady discussions all that time. You never, ever see an acting prosecutor participating in a public discussion of Brady. You just don't. And I applaud him for having the courage and the interest in justice for participating in this and telling us what happened, even though, you know, it happened when he was a defense attorney as opposed to a prosecutor. But it is important, I think, for prosecutors to speak up about this. And that's one of the things I want to talk about tonight. I guess I kind of drew the small or the short straw here. I have to somehow give the prosecutor's perspective on why Kurtzrock did what he did. You know, I can't get inside his mind, and I wasn't the lawyer on the case. So I can only base it on 30 years of being a prosecutor, seeing what goes on in DA's offices. I've run a prosecution clinic for the last 12 years where my students are working in prosecution offices. So I still, I think I have a pretty good perspective of what goes on there. But the question that I've been asked to talk about, you know, what's the prosecutor's perspective? I think it's important to define what prosecutor you're talking about, because there are different perspectives. You know, are you the DA? Are you a bureau chief? Are you a trial assistant? What county are you in? What's the philosophy of the DA's office where you're working? There are a lot of different perspectives, but one thing I can tell you is that what I've learned that Glenn Kurtzrock did in this case, it pains me from any prosecutor's perspective. It tarnishes the reputation of the 99.9% of prosecutors who go to work every day and do the right thing. And, you know, it's something that we just have to deal with. And that's one of the things I want to talk about tonight. I'm going to try to give you an insider's perspective on why these things happen. One of the reasons, obviously, is because you get a bad apple who decides, you know, that it's their prerogative to decide who's guilty on their own and make sure that that's what happens at the trial. But I think it's, you know, in a sense, it pains me that Kurtzrock is being scapegoated for this. And I mean that in all sincerity, because believe me, Glenn Kurtzrock didn't wake up one morning and say, I'm going to hide 2 years of the homicide investigation. This is something that happens in the office. It's not spoken about, but it happens. And it happens for one main reason. There's a systemic problem in DA's offices. It's been there. I started in 1979. It was there the day I started. In fact, it was there in my interview, and it's there to this day. And that is an obsession with winning convictions. And I don't care whether it's the Brooklyn DA's office, the Staten Island DA's office, the Suffolk DA's office, the Dallas DA's office. There is an obsession with winning convictions because DAs have to run for re-election, and many of them run on their conviction record. So, it filters down through the office to the staff that if you're going to go to trial, it's important that you win the case. Now, no one tells you, go out there and convict innocent people, or go out there and violate the law and make sure you get a conviction. That's not how it works. It works in that it's filtered down from the top, and it goes through supervisors, and then it goes through the staff itself talking amongst themselves. So let's start with the top. I always firmly believe that the ethics of the office start at the top, and the staff look to the DA for leadership, and the DA is basically a role model for what the staff does. And so when we have DAs who get convicted of obstruction of justice in federal court for conspiring to get police officers to lie in court to help other police officers who are their friends, that's not a great message that's sent to the staff. When DAs, I just read this in Newsday earlier last week, 2 weeks ago, when DAs make public statements about cases that violate the rules of professional conduct, specifically 3.6 dealing with trial publicity. There was a rape case in a local jurisdiction. I don't need to point that out. And the DA made a statement about the case, about the defendant actually. And the statement was, for this accused rapist, quote, "This is a dangerous individual. This is a convicted sex offender who is now off the streets." This wasn't after the sentence, and it wasn't after the conviction. It was at the time of the arrest. And 3.6 clearly says that a lawyer is not supposed to make public comments that could prejudice the proceeding. And there are certain comments that clearly prejudice the proceeding, including discussing the character of the defendant, a dangerous person, talking about a prior criminal record, a convicted sex offender, and talking about evidence that's never going to get into trial. In a rape case, the odds of you getting in a prior conviction for rape are slim to none. So that sends a message to the staff also. And finally, just today, I read about a prosecutor who presented a case to a grand jury in an effort to indict a police officer for the death of a suspect or a person who was an emotionally disturbed person. And the grand jury decided not to indict. And we have the prosecutor issuing public comments criticizing the grand jury and criticizing the criminal justice system for allowing something like this to happen. When I was taught prosecutors do not criticize juries, that they always reach the right decision, and that you should not be criticizing a jury in public. It's just something that denigrates the criminal justice system, and it's not appropriate for prosecutors to do it. So my point is, it all starts from the top, and then it works its way down. So I mentioned that this started for me in my interview. In my interview for the DA's office, I had to give an opening statement. And I gave my opening statement, and I was told that I did a decent job and I was going to be a winner. And from the first minute I stepped foot in the DA's office, everything after that was about winning. When I conference cases with supervisors, whether we should go to trial or not, the question was, can we win? Do we have enough evidence? Is the complainant cooperative? Are you going to be able to win this case? because they don't want to try cases and lose them. Basically, prosecutors are encouraged. They are encouraged to win. They are celebrated for winning, and they are rewarded for winning. This may be great on a baseball team, but it is not a great way, in my opinion, to run a district attorney's office. You might ask yourselves with Kurtzrock, where were the supervisors? He's just a line trial assistant. There's deputy bureau chiefs and bureau chiefs and executives, and every office has many supervisors. What are they doing? How is he getting away with this? Aren't they reviewing his work? So, to just blame Kurtzrock, I think is, just not seeing the forest for the trees. And then finally, with respect to Brady material, DAs are taught how to get around Brady. Not illegally, but legally. They are taught the exceptions to disclosure under Brady. For instance, we are taught, or I was taught, and it's still taught. I look at training material I received from some of my students who are now prosecutors, and they're taught that it's not clear that if the evidence is inadmissible, that you have to disclose it. In fact, the Supreme Court has never definitively held that the prosecutor has to disclose inadmissible evidence. And I'll even quote an expert on prosecutorial misconduct, not as expert as Professor Liebman and Professor Yaroshefsky, but he's a pretty heavy hitter, and that's Professor Bennett Gershman. And he wrote a law review article in which he said, quote, "A prosecutor who believes that admissibility is a prerequisite to disclosure has a valid discretionary basis to withhold evidence that might be highly relevant to the defendants." Now, Mr. Ahern has listed all this evidence that Mr. Kurtzrock didn't disclose. Most of this was evidence that someone else may have committed the shooting. It was second and third hand hearsay. It was rumor and gossip from people in the family of other people that might have done it. From my review of the court case, obviously I didn't have the evidence that Mr. Ahern did, but from my review, this stuff is arguably inadmissible. And I think that Kurtzrock has a good faith argument that since the Supreme Court has not said you had to turn it over, in fact, the Court of Appeals in New York has said you don't have to turn over inadmissible evidence. In that case, it was polygraph results, which are inadmissible as Brady material. To me, it's a good faith argument that, he did not commit a Brady violation. The second exception is that the evidence is not material. And the Supreme Court has spent dozens of cases and hundreds of pages trying to define when your prosecutor has to disclose exculpatory or impeachment material. And the test is it material to the outcome of the case? Meaning, is there a reasonable probability that if the defendant had this information, the result would have been different? Well, in this case, I think Kurtzrock had a colorable, a good faith argument that it wasn't material. In fact, the Supreme Court said in Strickler versus Green in 1999, quote, "There is never a real Brady violation unless the non-disclosure was so serious that there is a reasonable probability the evidence would have produced a different verdict." From my reading, again, I don't know the evidence like Mr. Ahern, but from my reading of the Second Department decision, the evidence against his client was overwhelming, okay? Overwhelming. One of the victims in the house that was burglarized, who knew Mr. Booker, identified his voice as one of the perpetrators. His former girlfriend, who was an accomplice, drove him to the scene of the burglary murder and got an admission from him afterwards that he had killed a person. His own brother, Booker's own brother, testified against him at the trial. His own brother, who was an accomplice, who went into the house with him and told the jury that his brother, Mr. Booker, is the one who killed the deceased. And finally, the DA had cell site location information, which according to the Second Department's decision, put Mr. Booker at the scene at the time of the murder. And there were cell phone calls between all the accomplices that connected them all together in this felony murder scheme. So even if that stuff was disclosed, I think there's a good faith argument, at least, that it wouldn't have made a difference. The case was that strong. Reasonable people could disagree about this, and I'm sure Mr. Ahern would, and I don't quarrel with him for doing that. If you look at the Supreme Court cases on Brady, which I've studied, for over a decade, most of them are 40, 50 pages long. They're 5 to 4 decisions. And the big distinction is 4 judges think it's not material, 5 judges think it's material, and that's what drives the outcome of the case. And so certainly I think there's a good faith argument for Mr. Kurtzrock here that this stuff was not material. My point is, I'm not looking to make a claim for Glenn Kurtzrock here, or defense. Again, it pains me for what he did. He should pay the penalty. We can talk about penalties. I'll be glad to discuss what I think should have happened to him. My point is that this is how prosecutors are trained. These exceptions are legal. They are approved by the Supreme Court. They are approved by the New York Court of Appeals. And, prosecutors are educated about this. Another thing to keep in mind, one of my colleagues, again, I'm honored to work with her, Professor Alifair Burke, has written a series of law review articles explaining the psychological reasons why ADAs, in good faith, trying to do justice, wind up not disclosing favorable evidence. It's just part of the culture in the office. And then finally, let's face it, legal aid lawyers, prosecutors, they're overworked. They have too many cases. Things fall through the cracks. Sometimes you don't get the chance to ask every witness you're going to call, hey, do you have any notes that I need to disclose? It happens. And we have to accept the fact that if you want to, pile up 25, 30 homicide cases on a prosecutor, that things are going to fall through the cracks. That's my prosecutor's perspective on what happened. Again, I'm not condoning it. I'm just explaining it. And if we get into a discussion about what should happen to Mr. Kurtzrock, I'd love to participate in that.
Thanks a lot, Fred. And I think you would have you would have been an excellent defense attorney had you. So,
nicest thing anybody ever said to me.
Yeah, there you go. So let me, there's been a couple of questions in the chat which actually were along the lines of questions that I was thinking would be good to pose to you guys anyway. So let me sort of start with you, Ellen, with sort of this two questions that are kind of related to something you said. You talked about how in some other jurisdictions there have really been some pretty harsh measures. I won't say harsh because that's a little judgmental, but strong measures taken against prosecutors for disclosure violations in some other jurisdictions. And there's a question in the chat about why would the disciplinary committee here be reluctant, or why might they not have imposed more serious sanctions on Mr. Kurtzrock? And related to that is the question that Fred alluded to at the very end, which is, do you think that, and I think I know your answer, do you think that this was the appropriate sanction, or should he have been disbarred, as other prosecutors in other jurisdictions have been for violations like this, or even criminally charged as prosecutors have been?
So thank you, Fred. Let me just say first, I think you've done an excellent job of setting forth all the factors why this is not a bad apple problem. This is a culture problem. It's disturbing to hear you talk about the training of prosecutors, although I know that. It's disturbing to hear about the culture of winning, although I know that. I can tell you, and we can talk about this later, in other prosecutors' offices around the country, in the more, quote, progressive prosecutors' offices, they are recognizing that emphasizing a culture of winning, is not the way to be ministers of justice. So that's a different discussion related to what it is you said. I think, Fred, though, at the end of the day, you've done a terrific job of trying to explain why this could have been good faith. I do not think Suffolk County would have fired Kurtzrock if they believed that this was done in good faith. So I'll stop there. So the disciplinary process. Look, disciplinary authorities in New York are not generally filled with people who are skilled people in the criminal justice system. The people that they generally discipline are what we might call the low-hanging fruit, right? They discipline people who don't return client phone calls, who don't stay in touch with them, who take clients' money. They really don't go after prosecutors, and they historically have not in New York or elsewhere, with rare exception, or defenders. They don't look at defenders who are engaged in terrible conduct. They don't go after big firm lawyers. So you first have to see what they're doing generally. I assume in this case, this was considered extremely seriously. They thought they were doing something particularly serious. 2 years for a prosecutor in New York is relatively unheard of. Why didn't they do more? I don't think they did an excellent job of looking at the evidence in the case. And frankly, had this been open to the public, right? Someone, or they had read the Innocence Project pleadings, they would have recognized that the mitigation that was put forward was just not true, that there were other cases here that Kurtzrock had been involved in. And I know that his defense lawyers are claiming that in the Lawrence case, the failure to disclose 45 pieces of exculpatory evidence were not his fault. There had been other prosecutors involved in the case, which goes back to Fred's point. This is it's an office-wide problem. It's a supervision problem. But nevertheless, they did not look at the other evidence. So one, I think it's what the disciplinary system is used to in New York. Why do they do it elsewhere? Well, Nifong was a front page story with many prominent, shall we say, white upper middle class kids who are charged, right? That's not what we're talking about in most of these cases. And Nifong, frankly, was all over the press and did much worse stuff, if you will. We can go through it than Kurtzrock, right? But there aren't that many cases around the country where anything's really been done seriously. The only reason in Texas that anything was done is they have a special procedure. They have a criminal procedure for putting the prosecutor on trial, the Court of Criminal Inquiry. One could say maybe we should have that there. Maybe we should do what California did, which is adopt a law that says it is a criminal violation for a prosecutor to intentionally withhold evidence. And maybe then, Fred, we wouldn't have the kinds of issues you're talking about in an office, because people would now have to be trained. If you don't turn this over, a court can later, you can later get indicted for not doing so. There's questions as to who would indict you, right? It can't be the same office. But if there are greater mechanisms of accountability, perhaps we would change the kind of culture that Fred is talking about. Tayo, I wanted to say one other thing, if that's okay, about the ethics rule. Can I do that? So one of the disappointments about the Kurtzrock opinion was they talked about this is a violation of the rule of professional conduct, 3.8b in New York. For those of you taking the MPRE, it's 3.8d. It is the rule that Tayo mentioned in the beginning that says, as an ethics matter, the prosecution has an obligation to disclose all information that tends to negate the guilt. It doesn't say admissible evidence. It says information. And there's an ABA opinion, there's a New York State opinion, there are court opinions that disagree on the subject of whether the ethics opinion is broader than the law, okay? They had the opportunity in Kurtzrock to opine on that, and they avoided it. They just said he violated the ethics rule, and then they talked about Brady, but they didn't go so far as other jurisdictions to say, and by the way, 3.8d requires disclosure of information, whether or not it's admissible, whether or not it's material, and the timing means it must be turned over and time to be used, even for a guilty plea. That's what the opinions say about the ethics rule. And it's not that it's up in the air in New York. We have an ethics opinion that says the ethics rule, the ethics obligation of prosecutors is broader than what Fred has set forth as, the state of the law, where prosecutors are basically figuring out, as Fred points out, how do you avoid the obligation? Instead, if people were trained properly on the ethics obligation, I don't think we'd have the same extent of the problem.
And in answer to the question about what, if you were in charge of sanctions, if you got to determine the sanctions here for a violation like that reported in the Kurtzrock case, what do you think the appropriate sanction is?
Well, it wasn't just one case. I think you have to, like when you're doing a sentencing in a criminal case, you're not just looking at, oh, this person violated this once. It's like you're looking at what they've done before, their criminal history. He has the equivalent of a criminal history. Now, the problem is that would make them then have to go try the Lawrence case or try other cases, that they weren't just going to accept allegations that he was involved as Newsday. I only know the rest of this from what Newsday reported, which is 5 homicide cases that were overturned because of his misconduct. They would have to look at that, but at the very least, they should have looked at it, and they didn't look at that at all, is my understanding. It was not. You can't say, because it's all done in secret. It was not in the opinion, and I know that the Innocence Project materials that were later submitted included it. And that's the way that I know the facts of that. So I don't look at some point there, it's not just his fault. It may be the fault of the office. I agree with Fred. I agree there needed to be supervision. We need to look at culture, but someone has to be held accountable here. And he's the person. I do think that this merited disbarment.
And Fred, you had said you were willing to offer an opinion on that issue too, what the appropriate sanction would be. So I'll ask you what you think.
I want to start by saying I feel very uncomfortable talking about somebody I knew and what kind of sentence he should receive based upon, newspaper clippings and whatnot. But here's my take on it. Frankly, Ellen, I'm not really bothered or appalled by the 2-year suspension. I think that's a significant punishment of a young lawyer who has no earning capacity. What's he going to do now? He work at Starbucks, drive an Uber. He's got a family. He's got kids. I don't look at that as a slap on the wrist. I think that's a significant punishment. He will never, get another reputable job. Who's going to hire someone with this kind of reputation? But I'm going to throw you a curveball. I think he should, if the facts were as I think they are, I think that Kurtzrock deliberately, just like Brendan said before, surgically removed this stuff because it knew it would hurt his case and he didn't want to do it. I believe that's what happened. If that's what happened, I think he should have been criminally prosecuted. I think he should have been, like you say, I think he could have been prosecuted for the misdemeanor of official misconduct. And I also think possibly a felony of tampering with evidence. That's assuming that he really did the bold move of purposely suppressing evidence that was going to hurt his case. But I don't, he's got to be in his, early to mid 40s, maybe. He's got a family. To disbar this guy over what could have been a good faith mistake of law. Even in Nassau, he was not known as a scholar. I don't know. I think that a 2-year suspension from earning a living is a significant punishment.
So Brendan, I'm not going to ask you what you think of the sanction in this case. You're free to offer your opinion on that, of course. But I am curious, as someone who was a young prosecutor in a prosecutor's office and then on the defense side and now has a more senior position, I'm curious about your thoughts about what Fred was saying about the culture in prosecutors' offices. And do you feel that now, and does it feel different to you from when you started and from when you were a junior DA and now from a more supervisory position?
Sure, and I am going to refrain from commenting on any opinion regarding the imposed punishment, but I will certainly respond to your question. One of the great benefits that I have from my perspective in my current position is having had the benefit of being on both sides of the fence. And so when I look out to the two offices here on Long Island in Nassau and Suffolk, I have great hope because I look to the leaders, particularly that are in place right now in DA Madeline Singis and my current boss, TA Tim Sini, because I've heard the message that Fred has spoken to in his I believe 2010 scholarly article. That I could say is in many respects, I feel, a blueprint for the training and some of the modifications in the office that have been done by the current administration here in Suffolk. But coming up through Nassau County, I had benefit of looking up to really great mentors and leaders. I think of my bureau chief in district court as remaining one of my greatest mentors and instructors. And his message was very much about an open file discovery of if you are sitting there for a moment and considering whether something may be Brady or not, then you've already answered your question, and that should be turned over. And as I actually had the benefit also within Nassau of going from a line assistant ultimately to a position, a leadership position, where I was working with young prosecutors in district court as a deputy chief under DA Madeline Singis. And her message was very clear to her supervisors and her leaders that we were going to effectuate a culture of compliance within the office, and we were going to instruct on Brady, and there was continuous training. And in fact, in preparation for tonight's proceedings, I reached out to some of my former colleagues to ask about what they are doing in Nassau now. And it very much mirrors some of, I think, the very forward-leaning steps that we are doing here in Suffolk County. So I want to talk about some of those things because I think it's important and relevant to tonight's discussion. Part of the reason that I came on to this discussion, Fred said it's good to have a sitting prosecutor, is because I feel it's so important to be in part of this discussion. I think prosecutors need to be at the table and need to be joining in these discussions so that we can advance the cause of justice. And that's the same reason that I came out of private practice and back into public service under DA Tim Sini. He spoke about at the time of his inauguration, sort of consistent with Fred's memo, that we were going to be seeking the truth. We were going to be seeking out the facts, and that Brady was going to be effectively a friend of the prosecutor. It wasn't a burden. And I'm paraphrasing, but that was his message to the prosecutors. And then the first CLE that we had back in 2018 was by the DA himself, talking about Brady. And he was setting the tone with each individual in the office and the leadership in the office that we were going to be focused on creating a culture of compliance. And certainly, if you spoke to prosecutors in our office, we have a robust training program right now that's focused on Brady. But we've also changed the infrastructure here within the office to effectuate compliance. We've created a circumstance where our young prosecutors bring their discovery and their cases to their supervisors to review what they're going to turn over. And I think that's a terrific step because now you get that sort of cross-check going on. It's not a single prosecutor sitting in their office late at night making a decision of whether this should go over or not. They need to show their homework to the leaders in the office. And I think that is a terrific tool. We've also created internally, much like Nassau County, a DA disclosure base that allows for more automated disclosure. So we have people who their sole focus is on getting out discovery as quickly and rapidly as possible so that compliance is the focus. We've also taken our office into the 21st century. And I think that this was actually an important point, and it goes to Fred's point about legal aid attorneys and prosecutors having incredibly high case counts and are overburdened at times. We've gone paperless in 2020. And what that allows is for a supervisor sitting at their desk to, I can click onto my computer and look at a file that's out in one of our East End bureaus. And I can look through every piece of evidence that's been collected and put into that file. I don't have to drive out to Riverhead. I don't have to drive out to Southampton and pour through a paper file. I can now have our management in place to oversee that disclosure. And that, in effect, has had, I believe, given our ADAs the confidence that that's the message that the office is concerned about, that we're trying to shift the paradigm away from this concept that you've heard people say of, like Fred said, of winning, that the focus has to be on doing justice and seeking truth. And the last thing I'll mention is that personnel matters too, right? And one of the things that has been done, I believe, by both offices, but I know here, one of the things that happened when the DA was coming in 2018 is I was recruited out of the defense bar. Other leaders in the office, longtime criminal defense attorneys, were brought out of their private practice in as leaders. The DAs met with all members of the office and identified the additional leaders that were already here, because there are, as Fred said, 99.9% of prosecutors are public servants who came into this job to do the right thing. And so what happened is there was a recruitment of personnel externally that were focused on ethical compliance, an elevation of leaders within the office that are focused on compliance. And now we've recruited young ADAs over the last 2 years who I've sat in on those interviews. And I've heard the Hofstra law students, I've heard students from Toro, I've heard students from around the country who are coming and interviewing with our office because of the messaging on ethical compliance. And when they join our office, and these are my last point because I see the hands coming up, is they can look up into our office from folks that have been here for 2 years to folks that have been here for 20 years. And there's a camaraderie that's focused on the fact that we have great public servants, people of great integrity, who now are doing exactly what they love. They're prosecuting cases, but they're doing the right thing on each and every case. And that's the message that's constantly echoed by the DA to the leaders in the office and down all the way to all of our assistants and our interns. And I think that, I spoke with Professor Yaroshefsky offline, and I said, the last 3 years have been incredibly exciting to me because it's such a dynamic time when you have a group of people, over 200 attorneys in this office, each and every day coming in to try to do the right thing, but also trying to ensure that we're living up to the mission that the DA has set, which is to do the right thing on each case. And that starts with our ethical obligations. So I have great hope. I have great confidence because leadership matters. And I think that right now is a great time that we're advancing the cause of justice and moving offices forward with that type of ethical leadership.
So Fred, I know you have your hand up, but I want to know if I could just jump the queue. I have 20-something students, Brendan, on this call who are in my ethics and criminal advocacy class. And I'm sure tomorrow they're going to all want to come work in an office that does what you say your office is doing. So that's really encouraging. I just want to ask some questions about training. So you said you train on Brady. Do you train on the ethics rule? Because that's, I think, essential for every New York office to now train prosecutors on the ethics rule so they don't get hung up in what Fred's talking about, which is, playing games with Brady and finding out how far you can go under the law. And I don't know if you train on Rosario, like, do you take notes or don't you take notes for students? My students know that, in the past in New York, prosecutors used to say, don't take notes. If you write it down, you have to turn it over. So we want to get beyond that. So I want to know about the ethics training pre-plea. Are you disclosing Brady and Rosario witness statements pre-plea because that's part of the new discovery rules? And then one question that comes up, and this goes to some of the cures we've talked about over the years to try to deal with this problem is having judicial pretrial hearings on Brady compliance. And I'm just wondering what either of you think about that, because as we move forward, and it's great that you have technology in the office, I think that helps a lot. And if hopefully you have checklists as well so that supervisors can sit down with an ADA before a trial, before a plea, and say, have you turned over the following 12 things? You know, here are the categories. What do you think about having judicial hearings so that a judge can figure out whether or not there's been Brady compliance?
So that's a lot of questions there. Fred, I know that Ellen jumped the line or whatever between the two panel people. Is it okay if we give Brendan a chance to answer some of those before you're okay?
Well, absolutely. I'm just honored to be here.
No, I want to hear what your thoughts are.
I do too. I'm sorry.
What Brendan was saying.
When I heard training and I have my students on this, I just couldn't help myself.
You had to jump in. All right. So Brendan, you can see if you can parry those, and then Fred will have his say.
Absolutely, I'll do my best. What I'll say is that when the training program began sort of on day one and has been a continuous training program. So in fact, right now, even in the wake of matter v. Kurtzrock, many of our attorneys have been trained by, at this point, the New York State Prosecutor Training Institute, guiding principles on the ethics rules as well as the Brady rules. And we, every time those trainings are available, we use as a tremendous resource to plug our ADAs into external training. But internally, we're also planning, of course, a training on the matter v. Kurtzrock, so we can speak about the minutia and speak about all the details that are laid out in there, because you have the implication of Brady and you also have the discussion of 3.8. The training on ethical compliance also was followed up with setting up policies, and to answer your question about the breadth of disclosure. Before we moved from Article 240 discovery to 245 at the beginning of the year, our office had already set out a policy very early on in 2018 about Brady and discovery obligations. And it was very much without the stricture of the timing requirements in 245, which are a different discussion point. The breadth of the disclosure, I would say, was very much in tune with 245. And the design was that when disclosure went over, and this goes back to my point when I was talking about the Booker case and that cover sheet of the Rosario, there was also a focus on not just turning all of the required materials and seeking out and searching for Brady and Giglio material and disclosing that immediately. But there was also, if there was going to be something where a prosecutor makes a decision that it's not discoverable, that was going to be identified to defense counsel. So they were going to be put on to notice that, hey, there's something that we believe ought not be disclosed for a legal reason. And certainly there's categories of evidence and information that fit into that category in many prosecutions. And, I think that structure is critical. That's why I always thought that was one of the missing pieces of Article 240, was perhaps a notice requirement that if I'm not turning something over, let the defense know about it so they can make an argument to a judge. And I think that if you have that notice, it invites, perhaps informally, that type of judicial discussion. Because if you and your adversary do not agree about whether something should be withheld or disclosed, now you have the option to obviously go in front of a judge and deal with it, perhaps in a sealed fashion, perhaps in a sealed proceeding, if that's appropriate. But now you can have a third party that's going to hear from the attorney for the accused and make the arguments about how that evidence may be relevant, and the countering arguments about perhaps why it ought not be disclosed. And ultimately, you will have a judicial determination. So I think that our policies prior to 245 even, we're advancing that type of breadth of disclosure so that people are making determinations about trials or pleas that are informed. Certainly now under 245, that demand is codified. So the laws change, and so the office changes and adapts and makes sure that the systems are fully in compliance with the requirements of 245. And that includes, of course, those very tight timing requirements for when that material must be turned over.
Right. Brendan, I want to
answer your question.
I want to give Fred a chance.
Sure.
He had some obviously some feedback on what you had described in what you were saying about what your officers are doing. Go ahead, Fred.
Well, no, I appreciate hearing about that, but I don't want anybody to be confused. As I said before, nobody's trained to violate Brady. You know, you don't become an ADA and they teach you how to convict innocent people and break the law. From the days I started, the DAs would do the same thing. Brady's important. You got to comply with Brady. You got to do the right thing. You don't want to convict an innocent person, et cetera, et cetera. It's the little insidious cultural things that go on in an office. So for instance, let me give you two examples from local DA's offices, from my friends and my own experience. When an ADA used to come back to the office after leaving the courtroom after a conviction, in one particular office, they'd play music celebrating the conviction. Something like We Are the Champions, or Another One Bites the Dust, if that sounds familiar to anybody. They don't do that for trial acquittals. It's just a cultural sensitivity to reward or celebrate convictions. And it's insidious. You get young lawyers and they get caught up in this celebratory mood of celebrating that they just convicted another human being. There's another office that has a different celebration. They have cutout figures of people, you know, advertisements like the Marlboro Man for cigarettes, or Dos Equis Man from Mexican beer. And the people who win conviction, they come back to their office and those cutouts are in their office celebrating their conviction. That might sound trivial, but it's insidious that young lawyers are celebrated not for trying a case, because if you get an acquittal, you don't get the Marlboro Man. You only get them when you win. Talk about notes. I mean, this is a chronic problem that exists right up to today. And I don't care what the DAs say you're supposed to do or not do. There are deputies and supervisors and associates in the DA's office. If you ask them, why did they take notes of witness interviews? No. Well, why not? Well, because then it's discoverable. I got to turn it over to the other side. I mean, that's just an implicit understanding that I don't have to turn Brady material over if I don't document it, which is not what the law is. But there was an ADA in a local office that I saw had a shredder in his office. Now, what in God's name is an ADA doing with a shredder in his office? We're the supervisors. Ellen, you talk about the new discovery rules. To me, that's where the true reform in this lies. The ethics rule is too broad. It's too difficult to sanction. It's not specific. The discovery law is excellent, just excellent. And for any judges who are still on this program, there's a provision under Article 245, which gives the judges the discretion to require not just a certificate of compliance with discovery in general, but a certificate of compliance with Brady. And it certifies that the ADA has made reasonable inquiries of police officers for undocumented Brady material. So basically, they got to call the cops and find out, what do you got that you didn't document that might help the defendant? And they've got to certify that they did that. That's phenomenal. But if the judge doesn't use it, it goes to waste. So if any judges out there take this stuff seriously and want to be proactive, you should be having pre-trial discovery conferences, and you should be requiring Brady certificates of compliance and not just certificates of compliance of general discovery. And one more point. When you talk about the new discovery rules and how the DA's offices are jumping on this and it's great, I happen to know, I have friends in appeals bureaus all over the metropolitan area. Many DA's offices are interpreting the rules to not require impeachment material to be turned over with the regular discovery. Their interpretation is there's a wording difference in the statute that talks about witnesses, and witnesses don't come up until trial, and therefore they don't have to turn over impeachment material until there's an actual trial. To me, this flies in the face of the exact wording of the statute. The statute, in fact, says if it's vague, it's presumed to be disclosable. And so just, this stuff continues. It's just interpretations of the law to try to keep this stuff out of the hands of the defense.
Alan, I'm just wondering what your response is to Fred feeling that the ethics rules aren't going to get you where you need to get to, but it's more using the new discovery laws and some of the mechanisms that Fred talked about to resolve this, or do you have a different picture of what the long-term solution for this problem should be?
Well, I agree with Fred. I agree with everything that he said, right? In federal court now, they're starting to look at orders, discovery orders, because what Judge S. Sullivan found out was he couldn't sanction the lawyers in the Ted Stevens case because there wasn't an order. And so, yes, there needs to be an order. And that the statute needs to be interpreted the way Fred says. Long term, though, I think if the disciplinary authorities would take the ethics rules seriously, they do it in D.C. D.C. did discipline a federal prosecutor named Andrew Klein. They wrote in that opinion that the ethics rule is broader than Brady. It's broader than Giglio. Here's what it is. Materiality is not a standard. Timing matters. Information has to be turned over. Doesn't matter whether it's admissible or not. If there were a number of opinions like that, disciplinary opinions, I think it would be very quick before prosecutors start training on that. Instead of, Brendan, I know in your office you're doing trainings on ethics, but no one's saying, and the ethics rule trumps the law. You're not doing that in your office, I assume, because that's not being done because there is a narrow view of the ethics rule in New York. And until an authority says, this is the way it is, yes, we agree with the New York ethics opinion that says our ethical obligation is broader than Brady, we have a few opinions, then prosecutors will start to pay attention. I also agree with Fred that if there were some criminal, there's a criminal indictment, it would change, we'd have a game changer there. So that's a long-term view, right? That the ethics rule has some teeth. We've not had teeth in the ethics rules. We haven't even talked really about the ethics rule up until the last 10 years or so in any serious way.
One of the things that Fred Brewington was going to talk a little bit more about, and Ellen, maybe you can speak to this a little bit, and it's something Brendan actually mentioned, which is this idea that the victims of the crimes that are being tried can sometimes be the ones who suffer as a result of violations that are discovered as well. And I'm wondering whether you want to elaborate on that a little bit, especially because I know Fred Brewington was going to do some of that, and Brendan did raise it when he talked about how the family of the decedent in the Booker case did have that the reaction that family member had.
Yeah, I mean, I know Fred would do a much more eloquent job than I would talking about this, but we have to think. I think Fred Klein said this. We have to think about the people involved. Right, the defendant has a family too. No one's thinking about the defendant who spent Booker's lucky that he didn't get convicted and have to wait 14 or 15 or 20 years on death row before someone discovered what Kurtzrock did, right? That's what happened to other people. So we have to think, when we talk about victims, we often think about victims only in terms of the actual victim of the particular crime. Well, in many circumstances as well, the victim and the defendant come from the same community. They know each other. They're the same family. Families all suffer. People suffer. We have to have a system overall, right, that where prosecutors are actually public officials who care about doing the right thing and doing justice. And so it really matters. Like Fred Klein teaches his students in the prosecution clinic about victims, meaning the defendant's family as well. People are involved here. And until we start focusing on people rather than using terms like defendant, victim, whatever other terminology we're going to use, and we start thinking about the ways in which we're thinking about the criminal justice system, things aren't going to change. Fred's completely right that if we're putting up Marlboro men, right, and instead of thinking about what you've just done, you've just sent someone away to an institution maybe for the rest of their lives. That has consequences. That should be a heavy burden that you bear for that person's family, for the victim's family. And we have to start thinking in those terms. There are many people who are now looking at restorative justice, which takes into account many of these concerns, and educating prosecutors about the need to think much more broadly than this win-loss record. But it's tough. It's really hard.
So let me, we have about 9 minutes left, and I want to make sure that everyone has a chance on the panel here I want to make sure you all have a chance to fully put forth like what you think are the ways to solve the issue of disclosure violations. And we've touched on a number of them already, including things like training for prosecutors, including things like leadership at prosecutors' offices, potentially using criminal charges in extreme cases. But I want to make sure everyone has a chance, if there are other areas where you feel that progress can be made, to fully put those out there. So Brendan, I'll start with you.
Sure. Thank you. One of, and I'm not just saying this because I have Professor Klein and Professor Yaroshefsky and Professor Liebman here on my screen, but one of actually the points that Professor Klein made in his paper is that a great service to prosecutors' offices will be actually to reach back into the university level, to the law school students, and to have things like a prosecutor's clinic that allows the new crop of prosecutors that are coming up to have training at the university level with experienced prosecutors like Professor Klein, with leaders in prosecutorial and attorney ethics like Professor Yaroshefsky, and begin to message right from there. And so we have some of Professor Klein's fine clinic members, in our office, and we look at them as the future, and I see that as a continuum. So I actually, I'm not trying to just puff up Professor Klein, but I believe that his 2010 article is a fine blueprint for how we can continue to make progress in this area. And you start at the university level, and then there needs to be messaging from the top, from leaders in the organization, that is the emphasis of the office, and it's about achieving justice. And we don't have Marlboro men in our office. I understand certainly the point that Fred that he's making, but one of the things that has become, I think, a really great point that we do here is the DA meets personally with every person that goes to trial. Not every person that gets a conviction. He meets with the people who get acquittals, the people who get convictions, and talks to them about their case, what happened. And at the end, he's talking to them about the good job that they did. And that includes individuals who have cases that result in convictions. And I think that sends a very clear message to people. You're going to get it's a big deal when you're a young prosecutor in particular, to get an audience one afternoon sitting with the DA talking about, some trial that you just tried. And imagine if you had gotten an acquittal and that meeting was going to be filled with anxiety, instead of knowing that you were going to go in and have a talk about, what'd you do? Did you do the right thing? What are the steps that you took? And review it. And at the end, talk to them and congratulate them for doing a fine job, and emphasizing them that justice was done. And I think that between that beginning place at the university level all the way up through the training programs, you follow Professor Klein's blueprint set out in that 2010 article, and you emphasize that the words that all of us have heard before, that a prosecutor's job is not just seeking convictions, but it's seeking and doing justice. And the last point I'll also make is I think that having all types of diversity in prosecutors' offices helps too. I think, bringing in criminal defense attorneys with the perspective of having sat with families of an accused and have experienced the ripple effect of the criminal justice system. And I did that in my time in private practice. I sat and met individuals who had a bad day, that the day that they were charged with the crime was, one of the worst days of their life, but they're not bad people. And you learn about that these are individuals, like Professor Yaroshefsky said. And I think that that's a great benefit, because I think that it gains you perspective, that you're dealing in a world of human affairs. And so I think by bringing in also diverse perspectives and diverse leaders and diverse members of the office, you begin to also understand that we are dealing not with victim defendant all the time. We're dealing with individuals. And I think that that's been a really important part, because I know as a leader here in the DA's office in Suffolk, that my time out in the defense bar and private practice benefited me. Because and that's part of the reason that I came back into this line of work, and I hope to do it for a long time, is I thought that perspective is something that can be shared, and it can be something that can benefit all the people around me. And so I think that's a little bit all over the place, so forgive me, but I don't want to take out all the time. But I think those are some of the things that we could do.
Good, thanks. And Fred, you're now the master of the universe. What would you do to fix these issues?
Well, in a minute and a half, I'll give you everything you wanted to know. I've already talked about some ways I think that officers can do better and things they should avoid. I'll give you 2 points. First, a little self-promotion: hire my students. If you hire my students, I guarantee you're getting people who are students and lawyers who are trained to do the right thing. They will never embarrass you. Once you get them in your office, it's up to you. Hopefully you could turn them into future Brendan Aherns, and we'd all be really good if we had a whole segment of prosecutors like Brendan Ahern. My second recommendation, a personal thing, for those of you, I know there are some ADAs on the program. When you're interviewing people, whether it's my students or not, it's really nice to look for mock trial champs and aggressive, articulate people. But I don't know that I'd make that the number one focus. I'd look for people with humility. I think that's a really undervalued trait. People that understand they don't know it all. They're not always right. I teach my students, you weren't there. You don't know what happened. You're just basing your decision on what other people tell you, and you don't know if they're telling you the truth. You really don't. So be humble if you're going to be a prosecutor. And it's the easiest way to do a good job and avoid convicting the innocent. Just be humble about it, because you don't know what happened. And hire my students.
Good words of advice. Thanks, Fred. And Ellen, you want to wrap it up for us? How do we make it all better?
Well, it's turning around a battleship. I spent a long time advising the new progressive prosecutors around the country. That's what they say. What Brendan's suggesting, trainings matters, supervision matters, leadership matters. Ultimately, Fred's right, it's culture at the end of the day. It's not going to be solved only internally. You're not going to solve Brady until you have some kind of accountability outside of prosecutors' offices. There's got to be internal accountability. There's got to be root cause analysis when something like Kurtzrock happens, or not Kurtzrock, negligent failure to turn over information, which happens repeatedly, right? Why isn't there an analysis of why did this happen? How do we change it? There's got to be root cause analysis internally. But judges have to step up. Judges have to start having hearings. They have to start sanctioning offices. Judge Allen Nathan is a good example. The Commission on Prosecutorial Misconduct, I hope it gets passed. I hope it has some teeth in New York. It does not look to me like that's probably going to happen. But at least if there's some external agency that is starting to pay serious attention And maybe Fred's right that we need to have some discipline. We need to have, I mean, some criminal sanctions. You need to have a special prosecutor appointed. That's not going to happen in most cases, but there need to be some examples made, because this is not like you're taking away people's lives. And I want to end with John Thompson again. Like he said, they tried to kill me. The prosecutor tried to kill me. What is going to be the consequence? There have to be consequences. I don't want to just think of this. These are not bad apples. These are cultural problems, and they need to be solved institutionally. It's not going to be done short term.
Perfect. Thank you. And I don't know if you had your eye on the clock, Ellen, but it is 8 o'clock exactly. So you did a great job. Thank you so much,
Thank you all.
Ellen, Fred, Brendan, and thank you for those of you who came to observe the panel.